Mr. Gore, is there anything suspicious about the fact that a map drawer knows the racial demographics of the state or has available the racial demographics of the state? Haven't we spoken about that?
Yes, many times this court has said that mere awareness or consideration of race doesn't prove racial predominance, and that would be particularly true in a state like South Carolina, which has Voting Rights Act issues.
Your defense was not something along the lines of, we looked at the racial data, but it didn't rise to the level of predominance. Actually, your defense was, we didn't look to the racial data for this purpose. And what the court said was, I don't believe that. Made a credibility judgment. You know, basically said, your map maker gets up on the stand and knows this racial data like the back of his hand. And the court says, I just don't believe that they were not looking at the racial data that was right there in front of them for the purpose of making their gerrymander more secure.
And that underscores the district court's error in failing to look at all the evidence. It's true the map drawer knew the racial composition of one precinct, one VTD. He didn't know the racial composition of other VTDs the district court asked him about, but he did know the political composition of those VTDs and testified to that at trial. Moreover, racial data is not a good predictor of partisan outcomes because racial data doesn't measure turnout or voting behavior.
You know, to the contrary, a presidential election is what doesn't measure turnout in a non-presidential year correctly. I mean, I'll just ask you this. There are two maps, let's say you have before you, where the election data says these districts favored President Trump. One has a 20% BVAP, and the other has a 17% BVAP. Now, doesn't any map maker look and say, you know, I would rather have the 17% BVAP in order to make sure that going forward this continues to be a Republican district?
I don't believe that's true at all, Justice Kagan. I think they'd look at how much the areas favored President Trump by. And in this particular hypothetical, if we use Berkeley
holding that constant, would you rather have the 20% BVAP or the 17% BVAP?
It would depend on other factors, such as compliance with traditional districting principles and other objectives the map drawer was trying to accomplish.
See, what this trial court found on the facts, on the evidence, was that the map makers made a judgment that they would rather have the 17% BVAP, because that, you know, along with the election data, they looked at this 1 year of the election data. But the 17% BVAP was what was, if we go above that, we're not sure we can hold this when another election comes.
The record did not support that finding,
well, let me ask
and it was infected by legal error.
How do you explain the consistency? I mean, my understanding is that thousands of people were moved in and out of this district, and yet that line, the line concerning the amount of, you know, black voter, adult voter participation remained the same. So if that was not, if what the court found here was not happening, how do you explain the consistency of that line?
We have a few explanations for that, Justice Jackson. So the first, to address Justice Kagan's hypothetical, is that the BVAP in draft plans through the drafting process actually changed. In the milk plan, it was 15.48%. In the staff plan, it was 16%. The enacted plan is 16.72%. The staff plan actually has a higher Republican vote share than the milk plan. So
was it ever higher than the 17? People were being moved around, and you would assume that if it was varying, it would do so in both directions.
People were being moved around, but not very many people. Remember that District 1 retained 93%, almost 93% of the district core, which explains why the demographic.
But 80% of the black people were moved out. Am I wrong about that?
That's not true district-wide.
Right?
That's not right district-wide.
I'm sorry, you said 93%? I thought it was 82.8%.
It depends on the method you use to measure, but the method that was actually used by the General Assembly was over 92%.
Well, that's not what the district court found. I thought it was 82.8, which was the lowest core retention of any other district.
But it was the highest.
And so how do you account for the fact that 68.9% of whites go to CD1, but only 50.65% of blacks do, that are Democrats? So you're controlling for partisanship, and the numbers are that disparate.
Because, again, you have to consider where in the district those voters happen to live and where the lines are drawn.
So it's okay for the legislator to say, I was looking at partisanship, but I'm not looking at whether someone was white or black. but I'm going to separate CD1 so that it's 100 miles apart in one county, and the only commonality is that they live all along I-26, 100 miles apart. And I'm going to join those two black sections, or get rid of them, and keep whites there, even though even though the Democrats could have been moved.
So this court has been clear that mere racial effects do not prove racial predominance. Moreover, the district court's analysis
the numbers are incredible.
We're looking at intent here. So don't those effects say something about the intent and whether or not the court, it was plausible? I thought, clear error standard was plausible. It was plausible for the district court to believe or disbelieve the "we're not looking at race" statement made by the person who was putting this together.
But the racial effects in this plan are far less stark than the racial effects in the Cromartie and Cromartie II plan, where this court reversed a finding of racial gerrymandering. So, for example, in Cromartie II, the line split a county and created a 72% BVAP area in one county and a 10% BVAP area in the other district.